And finally today, the NSA strikes back. Today, a federal judge in New York ruled that the NSA's bulk phone records collection program does not violate the law, and that it serves as an effective, quote, counterpunch to al-Qaeda. Those were the words of U.S. District Judge William Pauley as he dismissed a lawsuit brought by the ACLU back in June following the Edward Snowden disclosure that millions of Verizon customers in the United States were having their phone data collected and stored by the government. The ACLU argued such collection violated an individual's Fourth Amendment right to privacy and First Amendment right to free association. But in the 54-page decision, Judge Pauley argued the NSA's bulk collection program is not being used in a way that violated the constitutional rights of average law-abiding Americans. He notes there is no evidence that the government has used any of the bulk telephony metadata it collected for any purpose other than investigating and disrupting terrorist attacks. Now, this ruling comes less than 2 weeks after a federal judge in Washington, D.C. came to a different conclusion about the NSA's bulk phone records collection program. Judge Richard Leon ruled the program to be likely unconstitutional, arguing, "I cannot imagine a more indiscriminate and arbitrary invasion than the systematic and high-tech collection and retention of personal data on virtually every single citizen for purposes of querying it and analyzing it without judicial approval." With this latest ruling, it's looking more and more likely that the Supreme Court will be the final arbiter when it comes to the NSA's spying programs, although that will likely take a few years.